causes of action for discrimination, harassment. You have prohibition. Title VII doesn't just cover sex, it covers all types of claims. The ADA, which most people are familiar with, age discrimination. I remember Title VII applies for 15 or more employees. ADA applies for 15 or more employees. Age discrimination applies for 20 or more employees. And then in Pennsylvania, the Pennsylvania Human Relations Act, which essentially covers all of those, applies for 4 or more employees. And your status of when you're looking at and evaluating these types of discrimination, whether it's sexual discrimination or some of the others, are going to be very similar. And in many cases, the same type of evaluation. So when is an employer liable for harassment? Supervisor. And that's not a term that you get from Title VII. That's a court term that they pick up. And for those in the HR world, you hear supervisor in a variety of contexts. In the union setting, you have first-line supervisors and others. In wage and hour types of claims, you have different definitions. But for our purposes, it's an employee who is empowered by the employer to take tangible employment actions against the victim. And typically, like the tangible employment actions is any sufficient change in employment status, such as hiring, firing, failing to promote, reassignment with significantly different responsibilities, or decisions causing a significant change in benefits, right? So not everyone labeled a supervisor in your workplace may be a supervisor under the sexual harassment legality. But the key thing to remember here is it's got to be someone who has decision-making authority for important issues. And another note at the bottom, I can't say this enough, just because someone submits to an activity, sexual activity does not mean that it is not sexual harassment. If someone's job is on the line and they unwillingly submit, that does not create a defense. So outside of supervisor, and this is more common or something that you'll see more often, people complaining about, just your regular employees or coworkers. Court looks at this with a negligence standard. And what that means is that there must be a showing that the employer knew or reasonably should have known. So when we go back and think of pervasive, right? You got 5 or 6 people calling the same person a name. You got someone who, whether or not they were in supervisor under the statute, who has authority over them. Would that be imputed now to your employer? There's a good chance it would, because the more people who are involved, the more people who know, the more likely it's going to be imputed knowledge, right? And that you should have known even if you didn't know. And then, and we'll talk a little bit more about this, but an employer can be held liable for harassment of its employees if it fails to provide a reasonable avenue of complaint, a procedure, a grievance process, something where an employee can come forward and say, I am being harassed. In the context of non-supervisor, if an employer doesn't have this avenue, you can still be liable, or more likely will be liable, even if you didn't know, because you didn't create the avenue for it to be transmitted to you. Obligations. An employer can stop liability if you're notified of it by immediately investigating. This only applies in hostile environment, the quid pro quo. It doesn't apply, but if an employer exercises reasonable care to prevent and remedy promptly any harassing behavior, such as if the employee reports through their procedure, you start the investigation and you start that process early, you can stop liability. And that's really key for employers to do. For an employee, they're going to have to follow the procedure that's outlined for them. So if they fail to take advantage of the policy and process of providing notice to the employer, it can mitigate their ability to recover against the employee or against the employer, or impose liability against the employer. So what should we all do? First is train your employees. Having in-person sexual harassment training is key. Look, I know for cost purposes, a lot of times people want to do online training, and that can be effective. But in-person training, in my perspective, is more effective. It forces people to pay attention, forces people to be engaged. It doesn't allow you to sit at your computer and do work while the computer is running. It doesn't allow you to ignore what's happening on your screen and focus on other things. It's much harder to avoid paying attention in person when the individual is, or when the trainer is speaking to you directly than it is remotely. Set the tone often and early that there are serious consequences for violating the company standards. This ties in with create a top-down culture that prohibits sexual harassment discrimination. If there's separate standards for your management or for the senior management than there is for supervisors or others, people are going to pick up on that. People are going to pick up on how their boss acts. And if you don't set the culture at the top, they're going to believe that it's allowed at the bottom. Look, Joe, the supervisor's allowed to act this way. Why can't I? Make sure your employees are aware of the company's reporting and investigative procedures. And we're going to talk a little bit about reporting, but if you have a policy in place that says this is how you should report sexual harassment, these are who it should go to. If you don't give it to your employees to let them know about it, no one's going to know. How can someone file a complaint, or how can someone follow through with the harassment process if they're not given the material and not instructed on how to do it? If you're an employer, what do you want to do to be prepared? So we've been talking about a reporting procedure. You're going to want a reporting procedure that should have two options. The two options are so that the employee doesn't feel, in case that is the case, that they have to report to the harasser, right? Now, not everyone's big enough to have two reporting options. I understand that. That may not be applicable in some of the smaller companies, but if you have the ability to set it up where two people can take the report, it's always better than one, just in case one of the people who are being reported is the harasser. You're going to want to identify the key individuals in your company to put in that procedure that are going to be the reporters, whether it's your director of HR, whether it's your CEO or CFO, someone who has the authority, someone who has a position to be able to command and investigate, and someone who is knowledgeable in this type of material. You're going to want to make sure you train your supervisors that if they receive a report, that they need to immediately notify human resources. This includes oral, written. It also includes times when employees are saying, hey, I'm just letting you know, but I don't want you to take any action, right? Anytime it comes up, and many times, an employee may go to someone who they think is their supervisor. It may not be their supervisor, right? Or in our definition of supervisor, it may not be someone who has the ability to hire, fire, discharge, but they think it is. They think that that's the person who on a daily basis is telling me what to do, how to act, what jobs I can and can't do, and they're going to make a complaint to them. If that person gets it, and they may say, oh, I'm not a supervisor, I don't have to deal with this, you could still be liable for that. And think about it from just a human perspective. Do you really want someone who's coming forward to be minimized or marginalized in that manner, right? So make sure that you're telling everyone who is interacting, whether it's supervisors, other employees, that if you get a report, if it comes out, and even if someone says, I just want someone else to be aware of it, you need to report it up to the appropriate person, and it needs to be dealt with. Ensure employees that are filing reports or complaints don't have negative impact affecting their job. You saw that status back at the beginning, or the statistic back at the beginning, that only 10% of people who are sexually harassed are reporting. It's because of the negative consequences that they feel are coming about it, how they feel that it may affect their employment, or how they feel that it may affect them socially or with the other employees. The best thing you can do is make sure that there is an accepting environment for them to report, and that it is dealt with in an immediate manner. And that ties into the bottom, that you're immediately dealing with retaliation. I'd like to say that every employer is never going to retaliate. It's just not the case, right? It may happen, and if it does happen, be prepared to deal with it. So employers should be prepared, have a plan for investigations, right? Your policy is going to tell you that where the report is going to go. Sometimes it's going to outline what your next steps are going to be. If you plan in advance for how you're going to handle an investigation, whether it's going to be handled internally through your HR, whether you're going to refer it out to an outside professional, whether someone besides HR is going to deal with it, you'll be prepared for when it comes to handle things immediately and effectively. Because remember that in a prompt investigation will limit the company's liability, but it also will help the individual feel that they're being heard and that their point of view is being taken seriously and that they're not being marginalized. So what should you do once a complaint is reported? Let the employee know that you're taking this seriously, have the discussion with them, and then start the process of the investigation. Whoever's doing that investigation, you want to get down some information early from the victim, and you want to get complete details, information, so that things don't shift later, right? You don't want to be leading when you're asking questions if you're doing the investigation yourself. Leave it open-ended. What occurred? How did it occur? Did they touch you? What was said to you? Don't be direct of, they touched you on the leg, right? They said this, this, and this to you, right? Let them tell the story. Let it come from them as to what is actually occurring from the victim. Don't enforce or project onto them so that you're getting a true and accurate statement from them that later, when, if a story changes, it could be from the investigator's initial discussion. If you're projecting on how it, or telling them how to answer questions, they may feel that that's the way they should answer them. And that may not be the case. Take immediate steps to prevent future harassment. Even at the allegation stage, if you can separate individuals while you're figuring it out, put them on different shifts, it's not a bad thing. Investigate without delay and fairness. That's a key thing to remember, that an allegation is made, and I don't want to discredit those allegations, but at the same point, you want to hear from the other side too. So you want to get both points of view. You want to hear from everybody. You want to find witnesses as well. Keep the report and allegations confidential. There's no need for multiple employees to know about it. There's no need for your entire staff to know about it. Keep it limited to the individuals that have to have knowledge of it. And then when you're doing your investigation, make sure that you're informing, the witnesses. Make sure you're informing the victim. Make sure you're informing the alleged harasser that they need to keep it confidential as well. Confer with company attorney as needed. And just a promo for me, if you don't have a company attorney, feel free to give me a call. The complaining employee should receive follow-up on the results of the investigation. So as it says there, I'm not saying that you detail everything that you did to the complaining employee, but at the end of it, they're going to want to know. They're going to want to know that you took it seriously. They're going to want to know that their complaints have been addressed. And even if it's, even if you find that it's not substantiated, or if the allegations aren't there, they still deserve to know. They've come forward, they've informed you, and make sure you keep everyone informed at the end of it. And that even applies to the alleged harasser. And then something that people forget to do is monitor the situation after the investigation, right? You may have put things in place. You may have changed certain practices. If you don't follow up and make sure that things are going smoothly afterwards, you could just be going back to the old way, an old cycle. So after you've done your investigation and you find that there's credible evidence to support an allegation, what are you going to do? The first thing is that no matter who the offender